going to jump into our Unit 5. That starts on page 84. This section is going to talk about methods of transferring title. And if you want to think of title transfer, there's two main ways that title gets transferred. And that is voluntary alienation, which is just a fancy way of saying that the owner has agreed to sell or grant their property. And then there's involuntary alienation, which is a fancy way of saying the owner has not agreed to sell or grant their property, but it occurs anyway. The first section of page 84 really just describes what is a title and what is a deed. In practice, you'll hear title and deed used interchangeably. Title is simply the rights to the property, whereas the deed is the documentary evidence. The deed is the written instrument that gives someone the rights to the property. And alienation, as the book defines it, is just a fancy way of saying transferring property. So when you hear that word, you kind of get an idea of what it is. If you go down to about the fourth paragraph there, they tell you that the owner is referred to as the grantor. The person selling their property is the grantor. And the gray box on the bottom of page 84 gives you the technical terms that you're going to see on the test for the grantor, the seller, the offeror, the buyer, okay? The mortgagor being the borrower. So put a little star by that chart, because even if you don't see those terms used a lot throughout the actual text, they might use those on test questions when you get out there to take the test. But you will see grantor and grantee used a lot in your text. Grantee is the person receiving, the person buying. There are a few different things that are needed for the deed to be valid. So, you are listing a property, a buyer comes, and this instrument has to be a valid instrument that's enforceable, right? So in order for the deed to be enforceable or to be validly conveyed, and I'm at the top of page 85 now, the deed must be in writing, which makes sense, right? Because in order for something to be enforceable, it has to be in writing, and that goes for everything, So that's pretty straightforward. The grantor must have the legal capacity to execute the deed. Legal capacity, they must be at least 18. If they're not at least 18, they should have a legally established guardian. And they have to be legally capable, which means they're not declared insane or mentally ill or in any way would need a guardian to perform legal actions. Okay, so that's what that legal capacity means. The grantee must be named with reasonable certainty and must be identified. And what that means is that the grantee must be an actual person or an actual corporation. In other words, an entity that pays taxes. Because if you wanted to go back and donate a piece of property to your high school Spanish club, your Spanish club would have to be incorporated or something like that in order to accept the property. You can't just put on a deed high school Spanish club, because that's not a legal entity. Does that help? Does that make sense? Let's see, the next one. There must be adequate words of conveyance. Words of conveyance, also known as the granting clause, they are going to be a little bit different depending on the kind of deed that we're looking at. But generally, if you go down to that third to last paragraph and highlight the last sentence of that paragraph that says, depending on the type of deed and obligations agreed to by the grantor, the granting clause is usually going to look something like generally convey a warrant, remise and release, quitclaim. So that legal verbiage must exist somewhere on the deed. The next one is there must be an accurate legal description of the property being conveyed. So the legal description is going to be a lot of times the measurement of the lot, or from this tree northwest X amount of degrees kind of thing. A legal description is usually best determined by a property survey. So if you're representing a buyer who's buying a property, you would want to advise them that a legal property survey gives them the most accurate legal description for their deed. So the more accurate and current that survey or that legal description is, the more weight their deed will hold. Another tidbit just for practice for you to know when you get out there and you're selling property to your buyers, the property survey actually extends the title insurance to the boundaries of the property. So we're going to talk a little more about title insurance later in the chapter, but that is something really great for you to know and tell your clients. The deed must be signed by the grantors. Notice how it says the grantors and not the grantees. So the seller has to sign the deed in order for it to be valid. One of the second to last thing is that there must be something of consideration mentioned on the deed. So whether it says for $10 or for love and affection or for $100, it must mention something of value that's been exchanged. It doesn't have to be the exact purchase price, but something of consideration should be there. And the last thing, on top of page 86, it's going to have the paragraph, so I want you to turn your page to 86. We're going to talk about that a deed must be delivered and accepted. What that means is that the sellers sign it, and the buyer has to acknowledge that the sellers have signed it and they are accepting it. So delivery and acceptance must occur for the deed to be valid. If you go down to that third to last line and underline that sentence that says, in North Carolina, recordation of the deed by the buyers or their agent is recognized as acceptance. Now I'm pointing that out because if you saw a test question that said all of these are required for a deed to be valid except, much like the question you asked at the beginning. If you saw recordation on there, that would be the one that is not required. But acceptance or delivery and acceptance is required. But in North Carolina, we call that recordation. So if you see questions like that, don't get tripped up. A deed doesn't have to be recorded to be valid, but North Carolina's version of the acceptance is the recordation. So that's a little tricky, and the more we talk about it, it'll get easier to grasp. But one of the ways you can think of it is when you get out there, until the deed is recorded, you're not going to get paid. So The attorney is gonna sit down at the desk and you're gonna sit here and your buyers are gonna sit here and sellers might even be sitting here. And sellers are gonna sign their part, buyers are gonna sign their part, and then the attorney's gonna tell you, thanks so much. I'll call you when the deed is recorded and your checks are ready. So that's kind of a way for you to visualize what that looks like. Even though buyers and sellers sign, delivery and acceptance has occurred, we don't get paid till there's recordation. Okay? The book goes on in the middle of page 86 to well, you know what? Actually, in your packet, page in class 4 packet, your handout, there's actually a deed on there, in there. Should be, yeah. So take a minute, take just a minute and use your highlighter and highlight these things that are required. Highlight the essential elements of the deed in one color, and then after that we'll take another color and we'll do the elements that are not required after we go through that list. Take a couple minutes and do that. I'm going to do it with you. Do you have class 4? You're welcome. This is a real deed on a property that I worked on before. So, this is like a real deed, not a sample. What is your name again? Oh, yeah, I do have a packet for you, in fact. Yes, I do. Okay, so the first thing we see is what's the first thing you see?
It's in writing. It's in writing. That's what.
Right. Exactly. Next thing.
The grantor and the grantee.
Yep. They signed it. What about the consideration?
It's there.
You see that? $10. It's not the exact purchase price, but they put something in there. They paid me something.
We got the description.
Yep, and you have a pretty long description here, right? There's even a recorded easement on here. What about our granting clause? Do you see that? Grant, bargain, sell, and convey. Under the paragraph, under where it says witnesseth. You'll usually find the granting clause under the word witnesseth. Okay. On the first page, here in that second paragraph, grant, bargain, sell, and convey. The legal capacity, of course, you won't find on the deed itself, but because it is recorded by an attorney, one is able to assume that these people do have legal capacity. And then the fact that it was recorded is the delivery and acceptance by the buyer. Fun, huh? Okay. Now let's talk about what's not required for the deed. And on this deed, you'll see that a lot of these elements are here, but that doesn't mean they're required for a deed to be valid. In North Carolina, we kind of go above and beyond to make sure a deed is as valid and accurate and enforceable as possible. So for elements that are not required, deeds don't have to be witnessed. Technically, in olden times, property was sold between two people. There was not an attorney or a notary or anything like that. We do that today for practical purposes, but it's not required for the deed to be valid. Deeds don't have to be dated. Imagine that. We do for practical purpose, of course. Deeds don't have to have the exact amount of consideration that was paid. Deeds don't have to be acknowledged or notarized, although you notice on this one, they are. And for the next two, where I see a VIP and in North Carolina, that is 98% for sure going to be a test question. So put a little star there. Deeds don't have to be recorded to be valid. But in North Carolina, we have a state legislation called the Connor Act that says we do record. And that's North Carolina's version of delivery and acceptance. On a national level, not every state may record. But in North Carolina, the Connor Act says we do. And you're likely going to see a test question that says something along the lines of which of these acts requires that a deed be recorded, or which of these state laws, something like that. They want you to know the Connor Act is why we record. Another reason we record in North Carolina is to give something called constructive notice. Constructive notice means we made that written instrument public record. We made it public. We're giving constructive notice to the world that we bought this property and now we own it. That helps prevent against interference from third parties, because we bought the property and we made that purchase public information. So constructive notice is something you might hear, and really recordation and giving constructive notice are also synonymous. You're making that public information, public record. Okay, so there are 3 types of deeds in North Carolina that we use. The first one is the general warranty deed. That's discussed on page 86. The second one is a special warranty deed. And the third one that we use in North Carolina is called the quitclaim deed. They're all going to look pretty similar, but the biggest difference is just the guarantees of the deed, or that language that's on the top of the deed. So for example, if you look at page 89, that first paragraph under to have and to hold, those are the guarantees of the deed. If you look at page 91, at the top, under to have and to hold, those are the guarantees of a special warranty deed. And we're going to talk about, of course, a little bit more about them, but I want you to kind of get an idea that the deeds all kind of look the same, but that language is what separates them. And then a quitclaim deed, if you look at page 94, and look at that statement under to have and to hold, and this grantor makes no warranty, no guarantees on that deed. And we're going to talk more about those, about these deeds and what makes them different. So the general warranty deed comes with 5 covenants. So when you purchase a piece of property, one of the things that makes our country and our state so great is that we really do have the right to own property and have certain rights that come along with that ownership. The first one would be the right to convey your property. So you can buy a piece of property and sell it the next day if you want to. There cannot be any laws that invade that right. So there can't be zoning restrictions or subdivision covenant, restrictive covenants that restrict your ability to sell your property. Okay? The second covenant would be against encumbrances. So an encumbrance, an example of an encumbrance would be like a lien or something that would be a defect on your title. Encumbrances in the book are given as examples such as mortgages, mechanics liens, real estate tax liens, protective covenants, and easements. So property must be conveyed with the public knowledge of that stuff. I have a client who purchased a property, and he bought it it was like a real inexpensive piece of property that he knew the person who was selling it. Well, this person took total advantage of my client and the fact that he was paying cash. I didn't represent him on that transaction. He became my client later when he wanted to sell a property. But he came to me and he said, Yasmin, I bought a piece of property and I found out that there's a $5,000 tax lien on it. What do I do? And I was like, wow, so you paid cash for a property and you didn't do a title search, or you didn't have an attorney check it all out for you? He's like, no, I trusted the guy. I was like, well, that was your first mistake. So when it can get sticky in those scenarios, so when you're representing buyers who are paying cash, things like title searches and title insurance are optional because they're paying cash. A lender always requires title searches and title insurance, things like that. But this guy got himself into a sticky situation because now he either has to sue that person or he has to pay the tax lien off. Which one do you think is going to be cheaper for him?
Pay it off.
Exactly. He would probably spend $5,000 to $10,000 just pursuing that. So one of the reasons why when you're practicing and you have buyers who are paying cash, even though they can cut corners and save a couple of $1,000s here and there on insurances and attorney fees, you know, you always want to advise them that they ought not to do that. They ought to opt into the title search because they could get stuck with something they don't want. So the covenant against encumbrances is a big one. If somebody still has a mortgage outstanding on their property, they must be able to satisfy that mortgage with the proceeds of their sale to convey. So it's not like a person has to own their property free and clear in order to sell. You know what I mean? Okay. I'm on the top of page 87 now, the covenant of quiet enjoyment. Quiet enjoyment just means that no third party interference. Nobody's great-grand stepson to come in and say, hey, this property was sold and I didn't get my cut. Okay, so protection against third party interference. Covenant of further assurance. What that means is that if there's an error on the deed, like let's say the grantor's name is misspelled or something like that, they have to fix that so that the deed is as valid and accurate as possible. If you're under contract in a property and something like that is revealed, that it can be corrected pretty easily, it's usually not a huge issue. And the covenant of warranty forever, which is why we get title insurance, the grantor is basically saying if anything happens where the title fails, like let's say a third party does come and say, hey, I'm supposed to get a cut of this. The grantor is saying, in the covenant of warranty forever, if the title fails at any time, I will compensate you. A lot of times when that happens, the grantor's already dead, so they can't compensate you. So to alleviate that, we get title searches and title insurance because that's what title insurance does. Title insurance steps in if the title fails. So real quick, hold your spot here and look at page 103. Put your little star right there in the middle. See that long list of different things that can occur where the title can fail? If the grantor could, he would have to fix all these things for you, but oftentimes that's not possible, so the title insurance kicks in when things like this happen. Missing heirs, that's a big one. When a person passes away and then their title passes on to their heirs. You know, a lot of times a parent is not on the birth certificate, but that child might have other evidence that they're related to this person and they should have been included as one of the heirs. So things like that are referring to the covenant of warranty forever, protection against those things. Okay. The next kind of deed that you'll see in North Carolina is a special warranty deed. And the special warranty deed has two warranties, like it says in the margin, that the grantor received the title and the property was not encumbered by the grantor. General warranty says warranty forever, right? Special warranty is just warranty while I owned it. Okay? The only times in practice I've seen special warranty deed is if a purchaser buys a new construction property sold by a builder and developer. That is often those entities often use a special warranty deed because if a large tract of farmland has been in a family forever An attorney can really only trace the chain of title back to when it was conveyed to the developer. See, on a property that's already existing, they can go back and keep seeing who bought it, who sold it, who bought it, who sold it, because that's been recorded. But on a special warranty deed, the grantor is saying, I guarantee the property for as long as I owned it, which means I paid everybody to do the work I asked them to do. I paid all the taxes on that property while I owned it. Okay? I skip over bargain and sale because we don't use it in North Carolina very much. I've never seen it used. Instead, we actually use the quitclaim deed. So if you turn to page 92, we'll talk about the quitclaim deed. In the margin on page 92, it gives a really good, just in a nutshell, what a quitclaim is. And that is, there are no covenants or warranties, and it's usually used to cure a title defect. I see it used the most in North Carolina when spouses separate. Yeah, I heard the D word out there, divorce, okay? One spouse usually signs their rights off to the other spouse, and they'll use a quitclaim deed to do that. Okay, because the quitclaim deed is one spouse saying to the other, I release all my interest from all my ownership interest, and the property is now yours to sell. This is so important because, and we're going to talk a little bit later, but you cannot disinherit your spouse. So when you get married, if you own property before that you got with them, and then you get married, it's still part theirs. And if something happens to one, the other inherits the interest. So a lot of times that's why quitclaim deeds are so important, especially in the event of separation and divorce, because they don't want their other spouse to inherit anything that's not rightfully theirs. A quitclaim deed can also be used to cure a defect. I'm in the third paragraph on page 92, called a cloud on the title. A cloud on the title is just a fancy way of saying a title defect. You know how if a diamond is cloudy, the clouds are considered defects on the diamond, right? That's how I remember cloud on the title, because nobody likes a cloudy diamond, right? So that's how I remember cloud on title. So for example, if a person's name is misspelled or the legal description is not accurate, a quitclaim deed can also be used when a grantor has, and I'm reading the bottom of that paragraph, quitclaim deed can also be used when a grantor has allegedly inherited property but is not certain of the validity of the title. So a lot of times you will see a quitclaim deed going from a person to like a trust, because of maybe I own property but I want to put it into a trust so that it's already determined what happens to that property if something happens to me. I'll just quitclaim it to my trust. In a way, I'm amending the deed. Okay? We also use quitclaim on page 95. They call these special purpose deeds, but these are kind of just forms of a quitclaim, because these are much like, amendments to a deed. Like we talked about how we would use a quitclaim to make a correction to somebody's name. The correction deed. Okay? Another important one that you'll want to kind of know that exists is the deed of release. So, in North Carolina, when someone purchases a property and they get a mortgage, technically the lender is holding that deed until the mortgage is paid off. Once the mortgage is paid off, then you would want to, if you paid your mortgage off, you want to go to an attorney and say, I paid my mortgage off, I want a deed of release now. Okay? So a deed of release that's like a celebration day. You'll see a trustee's deed used generally to transfer title after a foreclosure auction. That's the last sentence of that paragraph. And you want to be familiar. You may see that term later, trustee's deed. And in addition to that, so if you owned, inherited, or bought a property that has a bunch of timber on it, and you got it real cheap, you might give somebody a timber deed, or you might grant a timber deed, where you still own the property, but a company has the right to come and harvest all your trees whenever they want. So that's what a timber or mineral deed is, like selling the assets on your property. Court order would be by will, and we're going to talk a lot about that in involuntary in our next section. So that pretty much concludes our voluntary alienation section and our description of deeds. Are there any questions about that, or